Rise.
Hearing in the appeal, Mohammed and Gomez and others.
Yes, good morning.
Good morning. May it please you this morning. My name is Ian Benjamin. I appear together with Mr. Roger Kowal Singh, who's to my left, and Mr. Pierre Rudder, who is to my right, for the appellant, and the respondents are represented by my learned friend, Mr. Ramesh Lawrence Marad, Senior Counsel, and he leads Mr. Robert Strand. My lady, this appeal concerns whether or not the Court of Appeal was entitled to overturn the findings of primary fact and the inferences of fact or secondary fact of the first instance judge, Madam Justice Judith Jones, as she then was, who dismissed the respondent's claim. Instead, the Court of Appeal substituted its own findings of primary fact and inferences. The facts that give rise to the appeal are summarized in the agreed statement of facts and issues, and if you permit me, I will take it in a summary fashion rather than taking that at length. In short, the claimants down below, each claim to be entitled to 3 individual parcels of land located in Morocco, St. Joseph, measuring respectively 5,000 square feet in the case of 2 of them, and just under 10,000 square feet in the case of the third. Those 3 parcels of land form part of a larger parcel of land, title to which was vested in the appellant. Although the facts describe the respondents of having occupied those parcels of land, it would be more accurate to describe them as having rented them for the purpose of building dwelling houses which they occupied. And therefore those parcels of land were leased as for the purpose of building upon them, which is what they did. In the case of the first respondent, she began her occupation and rental in 1966. In the case of the second, in 1958, and in the case of the third, in 1963. Around that time, there was an additional occupant who also gave evidence, and that is Miss Shafina Mohammed, and she occupied a 4th parcel, which is not in contention. The reason why that may be of some importance is because her occupation was contemporaneous with those of the 3 respondents, and she did give evidence in the case. Shafina Ali. At the time of the respondent's initial occupation, the parcels of land were then owned by Aziz and Edwina Andrews.
Edwina, is it?
Andrews.
I see. I thought it was Elvina.
Elvina, sorry, I do apologize. Elvina, I'm misreading my own handwriting. Elvina Andrews, and they are referred throughout, that is to say, both in the High Court judgment and in the Court of Appeal, as the Andrews, and from time to time you would have come across a reference to the Andrews Agreement, and I will explain that a little bit more in a moment.
Were they related, or was one of them related? I see that one was a cousin.
Yes, Elvina was a cousin to Syra's husband, who was Henry Stanley Mohammed. And so that all of the protagonists, if I can describe them fairly, have some relation, some familiar relation to each other. And in fact, all of the witnesses who gave evidence in the trial in 2014 were related in one way or another. And that is common ground, of course, between the parties. And perhaps for completeness, I could say that the first respondent, that is to say Mary Gomez, is the cousin of the appellant, Ashmeed Mohammed. The second respondent's husband, Henry Mohammed, was the brother of Hanif Mohammed, who's the father of the appellant, Ashmeed Mohammed, and his predecessor in title. And the third respondent is married to another cousin, Martha Gomez, who's also the first respondent's sister. By a conveyance dated the 14th of July, 1969, the Andrews conveyed the lands to Hanif Mohammed, that is to say, the appellant's father and his predecessor in title. And ultimately, in March of 2012, by deed of assent, Hanif Mohammed Ashbid Mohammed had the lands assented to him. Now, the way that the case was pleaded is quite important, and I would like, with your leave, to take you to the pleadings. And they are to be found in Volume 1 of the Record of Appeal, because it provides some of the context for the criticism leveled at the learned judge, who, as you know, dismissed the claim which the Court of Appeal overturned. So can I invite your attention to Volume 1, page 6, electronic page numbering number 6, my lady?
6.
There you will find the claim form, and I don't propose to read out large chunks of the pleading to you, just to make two small points. If you have page 6 before you, you will see over the page at pages 7 and 8 the nature of the relief that the respondents sought against the appellant. And can I invite your attention, first of all, to declarations 1 and 2? I trust my lady has it. They sought a declaration that they were entitled as, and I quote, equitable owners or such other benefited equity to the following parcels of land as the court considers just and equitable. And the second relief is in almost identical terms, save at the particulars A, B, and C. The parcels of land and their measurements are specified. Skipping over paragraphs 3 and 4 on page 8 of the electronic bundle, as well, can I invite your attention to 5 and 6, and you will see there that the way that the respondents pleaded their case, it was in the alternative that they are tenants of lands, that's paragraph 5, and in paragraph 6, in the further alternative, they sought a declaration, that is to say the respondents, that they were entitled to the benefit of the occupied parcel of land pursuant to the provisions of the Land Tenant Security of Tenure Act of the laws of Trinidad and Tobago. So one can see that the case was put in the alternative, and if I invite your attention merely for completeness to the very same form of relief at the end of the statement of case, you will find that electronic page numbering 35 to 36, and it is identical. So you need not turn it up if you can't put your hands on it. So we say respectfully that that's important for understanding the way that the judge approached the case down below. In other words, she had before her, first of all, a claim for equitable relief, proprietary estoppel, as the first and primary relief, and then secondarily, as far as the respondents were concerned, they sought alternative relief by way of a tenancy, but specifically pleaded reliance upon the Land Tenant Securities of Tenure Act.
Had the alternative case gone by the time of the hearing before the judge?
No, my lord, it hadn't gone. The way that the judge approached it was that I need to answer the equitable question first, and only if they fail on the equitable question do I get to the question as to whether or not these respondents are protected by the provisions of the Land Tenant Security of Tenure Act. And you will see that, just for your note for now, you will see that at paragraphs 30, 31, 32, and 33 of her judgment. That is to say, her approach.
Sorry. What was the position then under the claim under the Land Tenant Security of Tenure Act? Because, you accepted that they had been within that act.
Yes.
But they didn't serve, you say they didn't serve the notices.
Correct.
So, but there was an allegation that they had served oral notices.
That's right, my lord.
And what's happened to that?
Well, my lord, what my lord is remembering, first of all, is accurate. It was put that way in the two pre-action letters written on behalf of those who instruct Mr. Mirage. It's a letter, first of all, of the 12th of November, 2013, and a second letter of the 13th of December 2013, and they are annexed, of course, to the pleadings. So in those letters, and perhaps just for completeness, it's helpful just to take you to it, in those letters, they put, just as they had done in the in the pleading, they put their claim in the alternative, except that in the pre-action letters, they reversed the order.
But, Mr. Benjamin, if the judge knocked out equitable relief, then if it was still live, why didn't she go on to deal with the oral renewal point?
Because the oral renewal point was only raised in the in the pre-action letter, but not in the pleading. And she specifically says as much in her judgment. She says quite specifically, and she notices that although the point as to oral notice was taken in the pre-action letter, it was not pursued by way of the pleaded case, nor was it, as far as I read my lineage, and my friend is nodding, Mr. Maraj, that is, nor was it pursued. So that part of the case was abandoned.
My question wasn't very clear, but I intended to ask whether by the time of the hearing before the judge,
yes,
the alternative case had gone, and I thought you said it hadn't, but I think probably it had gone.
Well, Lord, I think the fault is entirely mine, and I think your question was perfectly clear, and my answer was not.
Well,
my
that's
answer is yes.
kind of you.
Good, thank you.
Right. So I was going to, just for completeness, take my lords to the pre-action letter so that you can see it, so we don't have to come back to it again. Can I invite your attention to electronic bundle page number 403? And after I've just touched on this letter very briefly, which I'm reasonably certain you've read, I'm going to take you to those paragraphs in the learned judge's judgment that sets out her approach. So it starts at electronic page number 403, and it runs to 405. That's the letter of the 12th of November 2013, for your note, my lady. And if you continue in your numbering on page 406, the second letter of the 3rd of December 2013, it's a much fuller letter, and it runs from 406 to 4112.
But for the record,
yes, my lord.
Now written only for Mary Gomez, not for the other two.
My lord, there are identical letters in the pleadings set up one after the other. So I think it's fair to say. So, my lord, if I keep on taking you through the pages, you will see that there are further letters on 413 to 420 and 421.
Oh, right.
I think it's accurate to say, to my lord, and my friend will correct me if I'm wrong, that with, of course, with the qualification that each of the respondents occupied a distinct parcel of land, and with the qualification that each of the respondents had been there for slightly differing periods of duration, the earliest in 1958, the latest in 1966, and of course, they built distinctive characteristic houses and did particular things. Their differences end. As far as their cases are concerned, insofar as they make an allegation about 3 distinct conversations that were separated in time by years, their case before the learned judge was that those conversations were ipsissima verba in identical terms. And so I think that's a fair way of putting it. It's reflected in the pleading and reflected as well, as you will see, in the witness statements. And the judge makes an observation about it. You will recall, I think, that the judge says, in relation to the respondent Mary Gomez, that her witness statement was not in her words. In other words, it reflected the words of her legal advisors.
So they went in at 3 different times, 58,
right,
60, 63, 63,
58.
66.
Yes.
And the allegation was that there were 3 separate conversations on each occasion.
Yes.
And as far as the letter is concerned, the assurance one sees on page 407 alleged was that they would acquire in the future a right to the lands if they continued to maintain them.
Absolutely, my lord, you got it.
Not with reference to any particular price or valuation at that stage.
Yes and no. In other words, no specific price was identified, but insofar as there was a suggestion that let me answer the question. I'm anticipating. Forgive me, my lord. In the letter, you are absolutely correct. In the pleading, it transformed, but just slightly. And that's really what I was going to answer. But can I just leave that for the time being and not be anticipatory? and just take you very quickly to the two aspects of the letter that I think are helpful to my lords and my lady. And I did say at page 404, you would get a clear statement on behalf of the respondents' legal advisors at paragraph 5, and I quote, "Our clients are statutory tenants of their respective parcels of land by virtue of the Land Tenant Security of Tenure Act." And my Lord, Lord Wilson, you will note that this letter is written on behalf of, from its heading, David Sari, Mary Gomez, and Shairu Mohammed. So there's no distinction being taken among the three of them. Your client, just to close off on the issue of oral notice, paragraph 6 is what I'm looking at. Your client is aware that each of our clients gave oral notice of their renewal of the statutory lease. Your client, in fact, acknowledged, and they go on. And then you get, so that's the averment that they are the beneficiaries of the protection provided by the Land Tenant Security of Tenure Act. And then you will see at paragraph 7 what I've described as the then alternative. They also contend, I trust my lady has it, that your client or his predecessors entitled, induced, encouraged, and or allowed our clients to believe that if they continue to live on their respective parcels of land, pay the land rent, and construct and maintain their homes, I'm adapting, on their respective parcels of land, that they would in the future acquire the right to their respective parcels of land. Our clients relied upon this belief and acted to their detriment, etc. And when you go to the more fulsome letter, which is to December the 3rd, 2013, over the page of 406, there is no difference, but of course there is more significant detail, because by then those who are advising have managed to take detailed instructions. But there's no deviation or qualification to the two core points that I was advancing, i.e. they were asserting protection by the Land Tenant Security of Tenure Act, and of course that they had the benefit of an estoppel. And that can be very clearly seen on 410, and their headings for the avoidance of doubt, paragraph 12 and 13, and over the page on paragraph 16 and 17. What is different, or what is clarified perhaps might be said by the respondents, from the letter on the one hand written in mid-2013 to the pleadings on the other, so I'm just going to ask you to go back to that, if I may. Can I ask you now just to look at 2 or 3 paragraphs of the pleading so that you can see what the evolution was. And I in particular invite my lady's attention to electronic page number 14, and I invite your attention to paragraph 8. And I'm going to give you the observation before I read to you. You will see in a moment that the generic or the generalized allegation of estoppel has now become specific and particularized. So it's not simply, it's gone beyond simply that they will have a right to own the land in the future, which is how it was set out in page 404. It has become much more specific. And the specificity is to be found in paragraph 8. And so it is said that the claimants went into possession of their respective occupied lands, I trust my lady has it, which at the time were forested, undeveloped, and appeared abandoned, etc., on the basis of the following agreement. So there's a plea of agreement with the defendant's predecessor in title, and that specific agreement is defined, and in quotation marks, as the said agreement and assurances. And you will see reference to the said agreement and assurances that runs through the following paragraphs of the pleading. So having defined the said agreement and assurances, the particulars are given, numbers A to D. The claimants at their expense would clear their respective portions of land and prepare the same to build their houses. They would be responsible for the expenses of providing all the physical infrastructure for them to build their homes and to maintain them. In consideration of doing the same, the predecessors in title agreed for them to live on the lands by paying a small land rent, and in the future, and this is where it gets more specific, my lady, they would have, and I quote, the right to buy their respective occupied lands at the open market value of the said occupied lands and undeveloped lands without the value of their homes and improvements. Put another way, in their undeveloped state at the point of entry into possession, i.e. at 58, 64, 66. So that's the degree of specificity that is said to emerge at this point, at the date of the pleading, but not in the pre-action letter. And then for good measure, the open market value of the undeveloped lands would be assessed as at the date of the agreement, which is the point I just made, with their predecessors in title and so on.
Is that, I mean, there seems to be a variation in the following agreement, singular,
Yes,
and the agreements.
yes.
Was the allegation that there was one agreement or three different agreements? And what was the date for the purpose of valuation? Do you understand?
Well, my Lord, I'm not, I want to be, if I can be helpful, I need to be certain about my Lord's question. Is my Lord asking me a question about the three different respondents?
Maybe it's for the other side to...
Well, it doesn't, I mean,
But it's just, I'm trying
try
to
my best to
understand how this was understood, how this pleading was understood.
Yes.
Because it refers to valuation at the date of the agreement.
Yes,
Which tends to suggest there was one agreement.
yes,
But as they went into possession at three different dates,
yes.
maybe that what was being said was that they were three separate agreements and the valuation was at the date of each.
My Lord, that's how I've understood the pleading. In other words, each claimant was saying,
I had an agreement.
I had an agreement on these precise and exact terms.
Yeah.
Mine was in 58, and the other respondent said mine was in 64. The other one said mine was in 66. But the terms were identical.
Yeah.
That's how I understood, how I've understood the pleading, and respectfully and much more helpfully to you, is I think that's the way that the judge understood the pleading. And so, again, just to assist, the way that this was referred to in the learned judge's judgment as either the Andrews Agreement or the option to purchase, which is obviously is what it is. And so that when you see those references in the judgment, they are shorthand to this paragraph. Paragraph 9, I'm not going to read to you. It simply says that the claimants, each of them relied upon those, but these words are important, my Lord, Lord Conworth, on the said agreements and assurances made by the Andrews, etc., etc. And the very last sentence is also important because it identifies the fact that as far as the respondent's pleaded case was concerned, they continued to collect the land rent on the basis of those agreements. So from their perspective, you've got a building lease in respect of which the appellant and its predecessors entitled are collecting land rent, but what is at issue in the case is not those facts as to whether or not there was a tenancy relationship, but whether there was something more, and in this case, it really comes down to the option to purchase or the Andrews Agreement. I think in fairness, I should invite your attention, without taking you through the detail of it, paragraph 10, because what happens there is that at paragraph 10, the pleader sets out the detrimental reliance of the respondents, and he sets it out in seriatim. So 10 concerns the first respondent, paragraph 11, the second, and paragraph 12. So each of them are particulars of the detrimental reliance. That's important because I just want to give a signal. It's an important observation for when my lords come to assess the Court of Appeal's analysis of the case that the judge had to consider, because you will recall that Justice of Appeal Raj Kumar says that an alternative case of estoppel was to be derived from 3 or 4 of the particulars paragraphs. In other words, the way that he analyzes the pleading is to say it's not simply that I have before me a case of estoppel in reliance upon the Andrews Agreement. He goes further and says there was yet a further alternative, and the way that my learned friend and I have dealt with it in our written cases is under the heading of proprietary estoppel, or estoppel by acquiescence, to be more accurate. But Justice of Appeal Raj Kumar identifies specific subparagraphs of the pleading in relation to each party and says that is the basis for an alternative cause of action, as it were, also under the rubric of estoppel. And respectfully, we don't accept that as accurate or reliable, but I will come to develop that at the appropriate time. But I just wanted to signal that while we're looking at the pleadings. I did promise you that I would take you through the judgment so as to identify the way that the judge approached the case. And with your leave, my lady, can I do that now? Madam Justice Jones gave her judgment in May of 2015. It's to be found in Volume 2, electronic page numbering 575. And can I just simply proceed with my thesis, which is a thesis as to how the learned judge below approached the case, which I say, and you would have got this already, I say she was right to approach it the way that she did, and the Court of Appeal wrong to demur, and I rely in particular at page 586. Can I invite your attention to paragraphs 29 and following? I'm just going to make some observations about what she says there. So it's electronic page numbering 586. And it's paragraph 29 of the learned judge's judgment, Madam Justice Jones, as she then was. And you will recall, let me just get rid of paragraph 29, you will recall that in relation to the third respondent, there was an unsuccessful claim for adverse possession, not appealed. I'll say nothing more about it. Can I go to paragraph 30 then? With respect to the estoppel, with respect for the estoppel to succeed, the claimants must establish, 1, that there was a representation made which is binding on the defendant, 2, the claimants relied on such representation, 3, pursuant to such reliance to their detriment, and 4, to deny the claimant an equitable remedy in the circumstances would be unconscionable. So it's a summary of the applicable principles of estoppel. She then goes on to say, and this is my point as far as these paragraphs are concerned at paragraph 31, if the answer to all or any one of the questions posed at 1 to 4 above is in the negative, then the claim must fail. And I must consider the effect of the Land Tenant Security of Tenure Act on their tenancies and whether the defendant is entitled to recover possession of the said lands. In this regard, it must be noted that by the reply and defense to counterclaim filed, the claimants, of course the respondents here, do not deny that in the absence of any entitlement to the equitable remedies claimed, the Act applies. So she was saying, by way of that compressed shorthand, the following. If the estoppel claim does not succeed, the Act applies. It follows further that if the respondents had not renewed their tenancy pursuant to the Act, the appellant was entitled to possession. And my lord and my ladies already have it from me with my friend's concurrence that he did not pursue the notion of oral notice. And therefore, there was no issue between the parties down below at any stage that no written notice had been given. And because I know that this board is familiar with the terms of the Land Tenant Security of Tenure Act, in broad terms at any rate, you will be aware that once the notice is not given, the 30-year tenancy that the Act specifically provides for by way of a statutory protection comes to an end. But I will take you, of course, to the provisions, and in any event, I think they're set out in my written case, and I know that my little friend makes comment on them in his. So that's the first approach. He sets it up with the alternative. The second approach, which we say is derived from and consistent with the pleaded case, is to be found at paragraph 32. With respect to the claim in estoppel, we leave out adverse possession. The burden of proof is on the respondents, nothing interesting about that. With respect to the estoppel claim, the case stands or falls on whether the claimants have proved the existence of the agreement relied upon by them, and if it is proved, whether the defendant is bound by it. With respect to the facts establishing the agreement, the defendant, by virtue of his defense, can lead no evidence. The success of this issue is therefore to be determined on the evidence led by the claimants, its credibility, and the weight to be put on it. In somewhat similar manner, the case, well, I don't need to take you with that, to that. And in case it's not clear, the reason why the learned judge makes the observation about the appellant is because he came long afterwards. He was not in the picture. The protagonist for the purpose of resolving that issue would be the Andrews on the one hand, and their immediate successor, Mr. Hanif Mohammed, the father. And I'm happy to do that. So the judge's approach was not simply derived from the pleadings that I've taken you to, in outline, of course, and I accept that, but also from the way that the evidence was led. In other words, the witness statements adduced by each of the respondents were designed to prove and establish the case that they had advanced. That is to say that they were in a better position than a simple tenant of building land, but they had the benefit of the option to purchase that I've already identified at paragraphs 8C and D of the statement of case. So that was the case. Everything else is a further and better particularization of it, dependent upon and parasitic, if I can put it like that, upon that primary case. And the learned judge had to determine whether the evidence that she heard and the witnesses that were cross-examined, whether she found what she heard and what was before her was credible and accepted. And as my lords and my lady know from reading the judgment, but I will take you to the salient paragraphs, she was not able to accept the evidence that was put before her. And because you have the judgment in front of you, can I ask you to look very quickly at what she says about it in summary form, and therefore I invite your attention to page 589. At paragraph 39, the very bottom of it, she makes a point that I've already made, and therefore there's no need to repeat it. And at paragraphs 40 to 41, she deals with the evidence of the first respondent, that's Barry Gomez, described as consistent with her pleading and so on, and summarizes what is said. In paragraphs 42 and 43, she summarizes the witness statement evidence. It's quite important. The witness statement evidence of Shaira Mohammed. And my lady, can I just ask your forgiveness and mention one point of housekeeping? I'm so sorry, I just overlooked it. There was a tiny issue as to representation. In other words, Miss Shaira Mohammed has since passed, but that's been resolved by consent between the parties. I don't know whether you picked it up in the notice of acknowledgement or in the written case. I should have said so at the very beginning.
Well,
I overlooked it, and I apologize for that.
don't worry.
So, my lady, yes, Shaira Mohammed, her written evidence by way of a witness statement summarized at paragraphs 42 and 43, and then similarly, for the third respondent, the evidence of Mr. Sami, or David Sami rather, who was the third respondent in the case. And then paragraph 46, she says, where they all speak about certain things. And then over the page is where you get to her assessment of their credibility and cogency. That is to say, from paragraphs 48 onwards. And again, she deals with each of the respondents separately.
And she goes into some detail about why she doesn't believe them.
And she goes into particular detail as to why she doesn't believe them. But the important point for our purposes, or for my lady's purposes, is that she finds on the whole that even though one witness or one party stood up better to cross-examination than the other, that's the case of Ms. Gomez, or another party it turned out it only emerged in the course of cross-examination, was not literate, that's Ms. Shaira Mohammed, and therefore the certificate at the end of her witness statement, which did not say that her statement had been read over to her, that she found that posed a serious issue as to the credibility and cogency of the evidence. And similarly, in relation to David Sami, she also found in the paragraphs that I'm sure you've read that his evidence was, I'll use my word, untrustworthy. She used a stronger word, but that's a neutral enough word for my purposes.
Mr. Benjamin, are you going to defend what the judge said in paragraph 48?
48.
Picking it up 5 lines from the bottom.
Yes.
2 things made clear. This action was not prompted from any desire on her part to purchase the land, but rather by the issue letter demanding possession. The language used in Ms. Gomez's witness statement, not her language, both of these, to my mind, affect her credibility. There is a suggestion that it doesn't follow from those points that her credibility was affected. Yeah. Would you like to defend that comment?
Yes, I would. Can I take the second first? Part 29 of the Civil Proceedings Rules and my recollection is that it's in identical terms in England, or similar terms, requires that a witness statement is in the language and the words of the witness. So that if a court is going to adopt the modern approach of post-Wolf, of permitting, as happened in this case, witnesses and parties to give their evidence in chief, not in a viva voce form, but in a written form, it is quite important. There is an obligation upon the legal advisors to ensure, and the parties to ensure, that what is on the piece of paper are their words and not the words of the legal advisor, because what the court is assessing is the evidence and not perspective on the evidence. And I say with respect that the judge was perfectly entitled, and she was right, because what she was identifying was a question of weight. Whether the words of any witness statement are the words of the witness is a question of weight, and if it emerges, as it did in this case, that those words were not this witness's words, then they diminish that weight considerably. Whether that diminution goes all the way to making the evidence worthless is a different point altogether. But it's a question of weight, and two things flow from that. The first is that's entirely a matter for the trial judge. The trier of fact must be in a position to assess cogency, believability, etc., of those words before you get to the question of cross-examination. That's the point that I'm on. And secondly, and perhaps far more fundamentally, as far as the appellate court's intervention is concerned, I say with respect, there's very little room for an appellate court to come afterwards and say the way that the judge approached this witness's evidence, comma, which was accepted was not in her words, was in error or should be challenged or should be overturned because it falls within what I would describe as the trier of facts prerogative, which is to weigh. That's not a matter for the appellate court, and my lady and my lords are well familiar with the legion of authority for which I derive that proposition. Can I go to now, my lord, listen to the first, which is to say, from her cross-examination, the other thing that emerged was that the action was not prompted from any desire on her part to purchase the land. Again, with respect, that's shorthand, because what this case is about and what the cross-examination focused on was whether or not this witness genuinely could be believed when she gave an account that she had a conversation with Mr. and Mrs. Andrews to the effect that this was an agreement that she entered into, together with her husband, to purchase the land. So it's not to be taken with respect as though what she was being referred to was a separate and distinct desire to purchase the land. It is in the context of the case and nothing more. And I can demonstrate that, if you like, by taking you to the cross-examination at the appropriate time. So the way that I have read the judge's observation, the full words are not prompted from any desire on her part to purchase the land, but rather by the issue of the letter by the defendant demanding possession. My lord would have noticed that later on in her judgment, in the vicinity of paragraphs 68, 69, 70, the learned judge says, and I quote, that she was concerned that the evidence being adduced by the respondents had an element of fabrication about it. And what she means by that, and so that's part of the context for this observation, what she's saying there is that it appeared that nothing had ever been said by this particular respondent that I have the benefit of an option to purchase. It had not been said to anyone, but much more importantly, at the point in time when she goes to her lawyer, having received a notice to quit, and therefore the demand that is being made to her, you must leave the property, demolish your house and go, one would have thought that that would be the opportune time to say in the most direct language, but I have the right to buy. And much more specifically, I have the right to buy on these terms. And so she was simply adverting to the fact that in the pre-action correspondence, 12th of November, 3rd of December, nothing of that specific sort was to be found. And therefore, in order for her to weigh up the oral evidence and the cross-examination that she has in front of her, and to answer the question, can I believe what I'm being told? So that's the context with respect, my Lord. So I say that 48, and I'll just give you the paragraphs for the purpose of completeness.
Well, we know what she said later.
I'm obliged, my Lord.
Thank you, Mr. Benjamin.
I'm sorry if the answer went on a little bit too long. As my lady has already observed, and I'm trying to make sure that I don't take it in such a lengthy and drawn-out way that I'm merely repeating a material that you are fully aware of.
Well, you can take it for granted that we have read the judgments in the courts below.
Absolutely, my lady. What comes across very clearly from this judgment is that there were a variety of reasons, all of which the learned judge detailed, for her being unable to accept the evidence of the respondents, and this next part is important, before any question arose as to whether or not there was any applicable statutory context. And of course, I'm referring to the Rent Restriction Act and the Land Tenant Security of Tenure Act. So that without taking you through the detail of these judgments, because you have read them, it's not until you get to paragraph 64, 65, is there any mention of the Rent Restriction Act. And so that what you have over the paragraphs that I've in part drawn your attention to, in other part I accept that you've read, you get all the way to paragraph 64, and you get a detailed catalogue of reasons why the trier of fact says, with respect, I cannot accede to accepting the believability of what I've been told so far. So you can draw, I say metaphorically, a line after paragraph 64 and I say with respect that up to that point in time, you get her detailed reasons for the conclusion that she's come to on credibility and believability. At paragraph 65, which is the first occasion upon which there's any reference to the Rent Restriction Act, and I'm on page 597, my Lord Conworth. At paragraph 65, what you have, in fact, is a response to a submission. It's a response to a submission. She says, the claimants submit that the fact of the permanence of the buildings erected on the land and the money expended by them in this regard is evidence corroborative of the existence of the agreements. I do not agree. So pausing there, what my little friend has done, with, if I may say so with respect, his characteristic skill, is he was advancing his fallback position. If you do not believe my clients, you can still find in my favor by drawing an inference from those things which are not disputed between the parties. And that was an argument that succeeded, we say, in error before the Court of Appeal. The matters upon which he relied upon, in particular, as providing the source of the inference, that they could be believed even though you reject their oral evidence, was the permanence of the buildings, and if you go to the Court of Appeals judgment, the family relationship, which I say with respect, so I don't have to come back to it, doesn't resolve the question one way or another. I say with respect, it's entirely neutral. It's entirely neutral, respectfully, except that it does tell you, does confirm that this is an informal arrangement. I entirely accept that. But
it talks about corroborative. So this isn't an independent point. This is the claimant submitting that there's evidence corroborative of what the claimants have said.
Absolutely, my Lord. Right? And she says, her answer is, I don't agree. And she goes on to give her opinion as to the nature of the buildings on the land and the rent receipts. And she says, they are, in my view, equally applicable to a finding that the claimants were simply tenants of building land under the Act and its predecessor, the Rent Restriction Act. And of course, the reference to under the Act there is the Land Tenant Security of Tenure Act. And indeed, the rationale, and she goes on, for introducing the Act was the protection of persons who were similarly circumstanced. So what we say about that is as follows. The judge is not making the error that is attributed to her of thinking that the Land Tenant Security of Tenure Act of 1981 was in play at the beginning of the respondent's entry into possession. That's not what she's doing. What she is doing is saying, testing, this is how I put it in my written case, and I don't resile from it. She is testing the cogency of the submission that's been advanced to her, that it's appropriate to look at the permanence of the buildings and suggest that it's corroborative of the agreements, in which, of course, it was the respondent's obligation to prove, because that's the submission that she has been advanced to her. And she is rejecting it and simply saying, look here, as far as the present is concerned, these respondents, as tenants of building land, have the benefit of, subject to compliance with its terms, the protection provided by the Land Tenant Security of Tenure Act. So that it is consistent with the fact of a building lease, in other words, a lease of land for the purpose of building, that it is of a long duration. My learned friends, I think, have provided us with an extract or authority from Lord Justice Millett, Bibby and Sterling. And he says very much the same thing. I think you have it among the loose papers that you have there. And in Bibby and Sterling, Lord Justice Millett is saying, with respect, what would be, I think, second nature to any chancery lawyer, which is to say, or any landlord and tenant lawyer for that matter, with respect, because I'm not a chancery lawyer, I want to put that out there, that a building lease or a lease of building land for this purpose, i.e., to enter onto to building dwelling house, would of necessity be of a more extensive duration than of a short duration. That's in essence what he's saying. He's simply articulating the unspoken premise.
You want to use the page reference, because it would be useful to look at his exact words.
Well, lady, I've only looked at the digest, so I hope you have two extracts.
Right.
So I've cheated, I apologize. I've only looked at the digest. So if you go to D37.
D37.
No, I don't think we've got that.
No, I think we haven't got...
We've got the law report. Well, we've got
sent me both,
yes.
and I've only got one. So I'm going to need my friends to tell me what paragraph it was in the.
The trouble is, it's not there. It's before the invention of paragraphs in judgments.
Yes,
So
I'm afraid I was bedazzled by it. Okay, so if my hold on. Okay, yes, thank you very much. My learned friend has been very cooperative, as he usually is. Can I ask you to go to the 11th page, if you can? So if you, or perhaps, yes. I don't know if counting from the back might help. It's 3 pages from the back. So I extracted what I said to you a moment ago. If my lady goes to the 1, 2, 3, third substantive paragraph, the erection of the greenhouse. So, of course, this is a case in the context of estoppel. And what Lord Justice Millett, I think it is, says, the erection of the greenhouse was consistent with the belief on the part of Mr. Sterling that he had a much greater right to remain in occupation than he would enjoy under a yearly tenancy or license. And so the key word for my purposes is yearly. It was consistent with the belief that he owned the land or had a long lease or right to remain indefinitely, which of course are alternatives of being advanced by the respondents. That is to say, as long as he liked, but that's not enough. The question is not whether his conduct was consistent with the belief that he had a relatively long tenure, but whether inconsistent with the knowledge that he had only a yearly tenant or license. Oh, let me start again. With the knowledge that he was only a yearly tenant or licensee, liable to be evicted at any time at relatively short notice, but encouraged by the confident belief along association with the neighbor and so on. So just pausing there, and I'm going to return that to my friend, my simple submission was that in the context of that case, Lord Justice Millett, if I may say so, made two helpful but plain observations. A, he says that in the context of the construction of the greenhouse, we can transpose that to the construction of dwelling houses, that they, having had the benefit of a lease of building land, would necessarily have a tenancy of a longer duration and certainly not limited to that of a year. That is borne out by the facts of this case. In other words, the facts of this case and the position of the appellant is that, yes, I am the successor in title to my predecessor landlord who agreed to each of the respondents paying me land rent and constructing their houses on that property. The difference between us is that they go further and they seek an option to purchase or a freehold right. All that the judge was saying, because of course this is the context of my observation, the judge was saying that in that context, Parliament has given additional protection. Going in reverse chronological order, the Land Tenancy Security of Tenure Act provides and establishes a 30-year lease. The Rent Restriction Act doesn't go quite as far, but it does provide restrictions upon rights to seek possession of the property and manages to control the rents. In other words, there are provisions, again set out in my written case, that provide a degree of protection for those tenants. So that the judge was saying as follows, in my respective view at paragraph 65, that permanent buildings, i.e. dwelling houses, are entirely consistent with leases of building land in respect of which there is putative protection prior to 1981 under the Rent Restriction Act by itself, post-1981 pursuant to the Land Tenancy Security of Tenure Act. And therefore, simply looking, this is the basis for her rejecting, simply having regard to the permanency of the building and saying that the only coherent or corroborative explanation to go along with those permanent dwelling houses is to say, and it must be the case, and I should therefore accept that these respondents had the benefit of an option to purchase. We say that the judge was right. Just to look at it, not simply in regard to whether she could accept the submission, but having regard to everything that she had said up to paragraph 64, by way of rejecting the credibility of the respondent's evidence.
Could I have a copy of D37 if it's convenient?
If you don't mind me surrendering mine, I'd be happy to do.
Thank you, I'm sure we could do with it.
You want to come to whether she was right about the Rent Restriction Act, are you?
Oh yes, absolutely. That's my next point, if I may. Yes.
I mean, is it right that this was introduced by her and hadn't been?
That is correct. That at this stage there was no, as far as I can tell, I wasn't in the court either at first instance or in the Court of Appeal, and I think my learned friend will confirm that the learned judge did mention these provisions. The Rent Restriction Act was not argued. I think that's right. It was not argued before her. And so, can I come now to the Rent Restriction Act question? I don't know whether I'd have to spend any time at all on whether I'm entitled to raise the point. My little friends had a word with me this morning. I don't know whether you've seen the letter of the 14th of October 2016. Can I ask you to look at it now, just for the purpose of completeness and out of absolute fairness to those who preceded me in terms of their representation. Oh, I'm so sorry.
I just gave my lady and my lord. I spoke to my little friend. I was not aware of that. It was a concession withdrawn before the court. David's. We are not relying on that point. The point in respect of the concession which was made in the Court of Appeal.
Well, just give us the reference to the letter because it will be helpful for
Yes.
for completeness of our notes.
I apologize. The letter only came to our attention. So it's a letter you should have on your desk. It's headed Mangal Singh. It's not in the record, my lady. But I see it to your right, to the right of your yellow marker in front of you. Or maybe that's Lord Wilson's. Let me not presume. Maybe just in front of your stable. There it is. So I'm not mentioning this letter for the purpose of, my little friend has, if I may say so with respect, very properly drawn to my attention the fact that he was not aware of this letter. I make absolutely no complaint about that. I'm on it for something entirely different. And can I ask you to just have a quick read of it, and then I will just tell you in a sentence what my position is.
Yes, thank you.
So you will see there, and can I also disclose that this letter was sent to be my lead counsel for the appellant, who was representing him before, that's Mrs. Deborah Preek. She made it clear to me that the position that they had adopted on reflection, because the Court of Appeal permitted them to consider their position, in other words, to consider what their position was in relation to the exclusion order. And her position was that the exclusion order was of no application and that the Rent Restriction Act was in play. Can I ask my lords and my ladies, just for completeness, for you to just look at the joint bundle of authorities so that you have it before you, the provisions of the Rent Restriction Act and the Exclusion of Premises Order. You will find it at tab 4, volume 1, page 3092. And of course, you will recall that I did reproduce some extracts from this in my written case. That's paragraphs 20 onwards, just for your note. And because I put it there, I am going to take it fairly briskly, if I may, with my lady. But if you have the joint bundle of authorities, you will see, first of all, on electronic page number 3094, the definition of building land. Do my lady and my lords all have it? I'm on 3094. Building land is defined under section 2.1 as land let to a tenant for the purpose of erection thereon by the tenant of a building or to be used as a dwelling. And therefore it's applicable. There is a further definition of dwelling house, which I'm not going to trouble you with. Can I invite your attention instead to section 3? That's page 3096, which defines the ambit or the application of the act. This act shall apply to all land which is building land at the commencement of this act. And for your note, the commencement of the act, it dates back to 1941. This act shall apply, subject to subsection 2 and sections 4 and 20, to all land which is building land at the commencement of this act or becomes building land thereafter. So for the purpose of our case, it is applicable. For completeness, can I invite your attention to section 3.2b? This act shall not apply to building land while let on a building lease or renewal or continuance of a building lease for a term of 25 years or more. That does not apply, but I draw it to your attention in any event. Section 4, and this is the last of the substantive sections that I'm going to trouble you with. The President may, if he thinks fit, by order, subject to affirmative resolution of Parliament, and I only want to invite your attention to C and D, exclude from the operation of this Act, that's 4.1c, I trust my lady has it, and 4.1d, exclude from the operation of this Act any specified premises. So with the exclusions identified, can I invite your attention to the exclusion of premises order. It's to be found in the next tab. It's page 3116. And you will recall that His Excellency has power to exclude either an area or class of premises. This is of the latter. So it's a 4.1d exclusion. And I'm on 3116. I'm not going to read paragraph 1, paragraph 2. The class of premises described in the schedule are excluded from the operation of the Act. In other words, it's a mirror image of what the section says. The only one that is in play here is Schedule 1, Part 1. And it says, as from the 12th of February 1954, all new buildings, the erection of which was completed on or after that date, together with any land appertinent thereto, to be occupied therewith. And for the purpose of the Act, the erection of new building is defined And the definitions are given: the erection of a building on land which was vacant immediately prior to, re-erection, etc., etc., etc. That's A. That's 1 to 4. And there is a deeming provision under B. So the difference between the appellants on the one hand and the respondents on the other is whether this applies to building land. We say with respect, on its clear and unequivocal terms, it does not. The Court of Appeal, I believe at paragraph 35, but I just want to double check, took a different view. And
Well, you say
we say,
building land even when a building is erected on it.
absolutely, my lord. And the reason why I say that, if I can just elaborate in a sentence, is because the tenancy is of the land. There is, in this case, and I don't have to go any further than that, there is no question of a tenancy of any of the dwelling houses. The very terms upon which the respondents contracted, because they pay rent, they pay land rent, measured in dollars of, it's $58 in one respondent. I mean, that's the currency equivalent to £5 on an annual basis, because it dates back, of course, to a very long time ago. So we say that the tenancy at play here in issue is a tenancy of the building land, and therefore any exclusion order directed to buildings is of no application. In fairness, the Court of Appeal took a different view. Can I just show you what they said?
Yes, I mean, just going back to section 3 of the Act.
Yes?
On page 3096.
Yes?
There seems to be a distinction between its application to, quotes, land which is building land at the commencement of this Act, or becomes building land, and to dwelling houses or public or commercial buildings. So you've got the distinction between the land and the buildings, arguably.
Absolutely, my lord.
Which would support your point that
Absolutely, my lord. Yes.
the order is simply concerned
Yes.
with buildings, not with land.
Yeah, my lord, there's nothing, I can't say a lot more about it. I simply say that...
Is that a point that was put to the Court of Appeal?
Well, as you would have seen from the written case, the way that, of my learned friends, the way that it emerged was that Mrs. Peake was not in a position to have dealt with it. I don't think she had seen the exclusion order, and therefore said to the court, I can't give you a definitive answer now, and he extracts that in his written case, and that's why the letter of the 12th of October was written, because the Court of Appeal at the end of the oral hearing said, if you've got anything to say to us, please let us know within days, and the hearing had finished a few days before, and the letter was dispatched.
Well, I mean, it's very difficult now to work out what was going on. Why do you think the order was made in these terms? Why was it suddenly decided to exclude buildings?
Any answer that I give to that question would be entirely speculation. I simply don't know. What is clear from the following orders is that there was a gradual reduction of the reach of the Rent Restriction Act. That's clear. So that in 1910 and the following years, you will see in the exclusions that follow, because they're all reproduced there, obviously they weren't made at the same time, they were made seriatim, one in 54, one in 60, and so on. The reach, so that, my lord, the speculative answer that I'm prepared to give you is that social conditions were changing. Not a very helpful answer.
I mean, was there a real shortage of accommodation?
Chronic.
In 1954, and Parliament decided to de-restrict, or to eliminate protection on new buildings to get people to build.
Absolutely.
So that all the inhabitants could be housed.
My lord, I think that's...
But how could it be that in the 27 years after 1954, before 1981,
yes,
there was no authority on this point?
No, my lord, it's not correct to say that there's no authority. What has happened over time is that you've got a variety of cases at first instance in the Court of Appeal that touch on very narrow aspects of both of the provisions. We've put a couple of those authorities in your bundle. My lady may recall that she sat on one together with Lord Walker.
Oh,
I'm
Gopal.
not testing your memory.
Gopal. Gopal.
Gopal.
Yep.
Wow. There you are. But but they percoled up to this level infrequently, if I can put it like that. So that it was in Gopal and in its predecessor, the Nanan case, and I'm not going to take you to it in any detail unless you ask me to. So at tab 22, you will see Ramdas and Bahar Nanan. That was a decision of Lord Walker, if my recollection serves me right. He sat with Lord Roger, Lord Collins, Lord Kerr, and Sir Christopher Rose, and he gave the leading speech, and he gave a touch of an outline. It was really in the Gopal case that my lady so well remembers that, and that's to be found at tab 11, that the social history that my lord has accurately intuited, or read, or both, is set out in some more detail. And of course, at that stage, I mean, this is a decision given in 2012, the Rent Restriction Act has passed into historical oblivion. The Land Tenant Security of Tenure Act, which ran in parallel to it, having begun in 1981, and still being on the books. So there was, of course, understandably a greater focus on that, but there was an attempt to give some of the background to the Rent Restriction Act.
Yes, paragraph 5 of that talks about the progressive withdrawal of
That's
various
correct.
categories of houses.
Absolutely, my lord.
But it doesn't deal with the question of whether there's a distinction between building land and buildings.
No.
That's not an issue.
No, my lord. And insofar as you look to me for giving you assistance on that, I say you start, of course, with the first principles, well known, as I put it before, to the Chancery Bar, and then you look to examine what is the statutory overlay. That's it. There is no distinction between the common law of Trinidad and Tobago and the common law of England in that respect. And that was the purpose of my mentioning on.
You said that section 32B of the Rent Restriction Act was irrelevant, but that makes it clear that building land is only excluded while actually let on building lease.
Yes.
So there's no question of a building lease here, is there, at any material time?
My lady, in answer to my lady's question, is there a question of a building lease here?
No. It indicates that building land,
While let on a building lease,
exactly, in the same way that the definition of building land refers to land let for the purpose of the erection
yes,
of a dwelling.
yes.
So when its dwelling has been put up, is it not arguable it ceases to be building land?
My lady, with respect, I say that the argument would not succeed because what the landlord is entitled to collect and what the tenant is obliged to pay is rent for the land only. And on the facts of this case, the purpose of the leases was for the respondents to construct their dwelling houses.
But once the permanent structures were put up, they became part of the land, so that they were actually
Yes.
renting the land with the houses on them.
But yes, but the landlord has not bargained for an increased consideration that purports to extract any value that might be referable to whatever the structure
That's
is.
not a criterion in the Act.
No, I'm not on the Act. I'm simply answering my lady's question in two ways. I say that there is a definition of building land which is applicable. My lady quite rightly says building land while let on building lease, and seeks to draw a distinction, I think, between those words there, because building lease is not defined, but building land is, and therefore my respectful submission is that the definition of, or the understanding or proper construction of building lease, as it appears in 3.2b, has to be entirely consonant with and consistent with the definition of building land under 2.1.
Yes, but if you read that as means land let, etc., it could be interpreted as means land for the time being let for the purpose of the erection of the dwelling, which it had ceased to be.
My lady, I wouldn't say that that is not an arguable construction, but I do respectfully say that it's not the construction that you should prefer. I don't think I can put it any better than that. So I had promised to take you through, or take you to the question of the Rent Restriction Act and its applicability, and I'm not quite sure whether I had made any observation in relation to paragraph 35 of the judgment of Justice of Appeal Rajkumar. I knew I was going to take you to it.
No, you haven't.
And then I was asked a series of very proper but difficult questions.
No, I don't think you had done that.
So can I do that for completeness? And again, while I'm not going to make this observation to be overly critical of the Court of Appeal, but can I say that all that you have by way of reasoning is to be found in paragraphs 35, which is the conclusion. So it's 33, 34, 35, and 36. And you can see what their analysis is. And I say with respect, I don't agree with it. And I don't agree with it because it's not faithful to the statutory language. And you get a hint of that in paragraph 35. Where His Lordship Justice of Appeal Rajkumar says, it's accepted that the appellants are tenants of land or buildings, and they had built their own buildings and were not tenants in respect of their houses, my Lady Arden. Nevertheless, their houses which were built after 54 were new buildings, and therefore were excluded. I say with respect, sentence 2 is what the Latin is called a non sequitur. It does not, with respect, follow. And I invite you so to find. My position in any event, as you know from my written case, is that even if you decide that the Court of Appeal was right in its construction and my submission is not acceptable, that it does not matter. And I've already given you a hint as to why it doesn't matter. What I mean by that respectfully is that the basis upon which the Court of Appeals felt that the threshold for intervention had been crossed was because, in their words, the misdirection or the error of law, because the judge did not come to the very conclusion that they did at paragraph 36, was material, that's their word, or core to her reasoning. And I hope that I have done enough, but I will make the submission anyway, by drawing your attention to what the judge actually reasoned up to paragraphs 1 to 64 to say, that's not so. It is with respect an unfair criticism of the learned judge to describe what she says at 65, and the two other paragraphs where the Rent Restriction Act is mentioned, because there are only 3 in her 75-paragraph judgment, to describe those observations in the context of responding to a submission by my learned friend that he had advanced as being core to her reasoning. You will recall, I'm sure, that in my written case, I described what the learned judge was doing as simply as a check. In other words, she was testing her own conclusions by way of looking at the submission and trying to see whether it bit as far as she was concerned.
What's wrong with the reasoning of the Court of Appeal? I mean, they say that even if you treat the building land as separate, nonetheless it's pertinent to the building, and therefore within the order.
I take it my Lord's question is directed to their construction.
Yes, what's wrong with their construction?
I say that it doesn't do justice to sections 2 and sections 3 of the Act. It seeks to isolate the language of the exclusion of premises order and turns it on its head. So on its face, it applies to dwellings, and they say, well, it also applies to the land pertinent to it. But it doesn't, if I may say so with respect, treat with the facts of the case that they had before them, which is to say that there was only a lease of building land. But I'm now back to saying what I said in answer to my Lady Arden. So, but my Lord, that's my respectful submission. I say it's if you have to choose between the two constructions, my respectful submission is as follows, that the one that I advanced is more faithful to the language, more consonant to it, doesn't require any distortion whatsoever. It is the construction which flows from the ordinary English language use of the words that are used, and the alternative doesn't do that. It is a strained construction, respectfully. My lords, I was getting into the, as it were, the consequential submission that even if you were not able to go along with my respectful submission that the construction is in error, that the Court of Appeal overstated its analysis and its contention when they purported to analyze the judge's reasoning as being, on this point, as being core or material to her conclusions. And so what they do is they highlight or zoom in on paragraph 65 and the two paragraphs that come afterwards, disregard the flow of her reasoning for rejecting the claimant's evidence, and then come back and seek to launch a series of criticisms against that reasoning as not going far enough. At the end of the day, my learned friends and I can exchange, as it were, opinions about that reasoning. But it really comes down to the following two things. The first is that the learned judge gave a series of reasons for her inability to accept the evidence. She was the trier of fact. And the second is that the Court of Appeal, in latching on to, with respect to them, a non-material difference of opinion, they say error, I say difference of opinion, in fact, created but did not find in her reasoning an error sufficient to warrant their rejection of her inability to accept the primary case being advanced by the respondents.
Mr. Benjamin, have you dealt with the alternative point that even if you were right to say that the Rent Restriction Act applied when these buildings were erected, the point really is whether the three respondents knew that they were protected or believed that they were protected, and there was no evidence, so it is suggested, that they knew or believed.
Yes. My Lord, not yet. And can I deal with that now?
Please.
Yes. So, my Lord, the way that case is put is that the claim for estoppel protection is dependent upon whether or not they believed or didn't believe, had or did not have knowledge of protection, either pursuant to the Rent Restriction Act and or pursuant to the Land Tenant Securities of Tenure Act. There is no evidence one way or the other in relation to the Rent Restriction Act because it wasn't put at all. So, with respect, it doesn't help my little friends, and it doesn't assist me. Insofar as the Land Tenant Security of Tenure Act is concerned, the evidence reveals this, that the respondents said in answer to questions in cross-examination that they either knew nothing about it or didn't know very much about it. But when they were asked the question, well, what do you have to say about what is contained in Mr. Miraj's letter, which is what I showed you at page 404 at the beginning of when I opened my case. And that is to say, in that letter, and it's worthwhile going back to it, and in fact, can I just prefer the version, because it's slightly fuller, can I prefer the version on 410, where what is said there in relation, and this is important, in relation to each of the respondents, because as I said to you, my Lord, before, the letters are identical. So if I invite you to 410, and I simply ask you to bear in mind that what is said there is that Mr. Miraj's client is a statutory tenant of the said parcels of land she occupies by virtue of. So that's the respondent advancing a positive case. I occupy this land by virtue of this act, and she has been in uninterrupted and continuous occupation, and the period of time is given. Then there is an exchange of contentions about Section 4, and the notice point is taken. Then over the page, an alternative contention is advanced, that there was an acknowledgement about the renewal of the lease, and therefore it ends, and this is important at paragraph 15, I'm on page 411, it is clear, therefore, based on the dealings between the parties, that our client continues to be protected by the Land Tenant Security of Tenure Act. So that you have a contrast which goes to 2 points. It goes to credibility and believability when the deponent, when the respondent, and each of them goes into the box and says, I don't know anything about protection under the Land Tenant Security of Tenure Act. And then the cross-examiner then asked, but what about the letter? Because the letter was written on your behalf. And to each of them, the answer is given, yes, I'm aware of the letter, and yes, my attorney, my legal advisor, explained to me what the Land Tenant Security of Tenure Act meant. But, my Lord, really 2 things. As far as this is concerned, because the Land Tenant Security of Tenure Act doesn't exist before, let me choose a date arbitrarily, December 30th, 1980. It's a 1981 Act. Its existence or non-existence, from that point of view, is neither here nor there. It can't help establish or support any state of mind advanced by the respondents at the time of entry into possession. They are therefore left with respect to their primary case. That is to say, as pleaded, not that we each had the benefit of an estoppel by acquiescence, but a very specific agreement. And I've drawn it to your attention already, paragraphs 8, C, and D of the pleading, i.e., that what I had was the benefit of the right to purchase my land, or the land that I occupied, valued at a particular point in time and valued on a particular basis. So that's how they put it. So the case as advanced by the respondents was that and that alone. Everything else was further and better particulars of that case. So I don't know if my Lord, I've answered adequately what my Lord has put.
Well, we'll have to judge whether that is an adequate answer.
Yes,
but
Lord,
you're a very adroit advocate, Mr. Benjamin. Thank you.
Lord, you're very kind. Yes, I'll leave that there. So, my Lord, I'm just kind of running over the question in my mind to see whether I have given you not an answer that you'll accept, but a complete answer. That's really what I was concerned about. Have I omitted anything? My Lord, respectfully, I don't think that I have. My respectful submission is that questions about the Land Tenant Security of Tenure Act and a case, because really what's happened on the respondent's side of the table is that instead of advancing before you in their written case, a case which flows from their pleaded case, they specifically say that what matters in this case is whether the respondents believed, and I quote, that they had security of tenure. Now, notwithstanding the caveat that I'm not a chancery lawyer, my understanding of security of tenure was that that is, in this context, a term of art. That is to say, it is a legal fact which either applies or doesn't apply dependent upon the language that Parliament has chosen. In this case, respectively, the Rent Restriction Act or the Land Tenant Security of Tenure Act. It does not depend upon belief or knowledge, and in this case, it is highly dubious when, with respect, slightly constructed in an artificial way to frame the case as though what was pleaded was a knowledge or belief about that legal fact. What in fact was pleaded and what in fact they sought to prove was, and I've said it already, shorthand, the Andrews Agreement or the option to purchase. And so we say with respect that the the thesis advanced by my learned friends in their written case, and no doubt to be advanced by them in oral argument, it is really a construction that does not reflect their pleaded case. It is a further departure. So insofar as they started off on one basis and felt unable to establish their case, and therefore had resort to inferences as their fallback position, there is now a further fallback within that context of knowledge or belief about security of tenure. And so respectfully, we say that their case, we adopt and accept the way that the judge put it at paragraphs 30, 31, 32, that their case in law stands or falls in accordance with the facts as pleaded and purported to be proved by them, which is what we say the judge was entirely unable to accept for all of the reasons that she has given. My lady, I propose now to, what I have left is really the material on lack of credibility. You have it in my written case, lack of corroborative witness testimony, lack of corroborative documentary testimony, neutral evidence. Can you forgive me, and can I ask that I not simply put in different words what I've written there, and allow me to focus on the inherent improbability aspect of the case?
Well, why not?
Yes,
Seems very sensible.
And can I, therefore, just in that context, invite you back just to that portion of the judgment. That's paragraph 70 to 74 of the Justice Jones's judgment, which talks about inherent improbability and implausibility. And I do so for two reasons. One, because we say that this is the learned judge pulling the threads together. And pulling the threads together, not just in relation to all of the points that I just summarized, and I'm on paragraph 70 and onwards, milady. This is page 599 of the learned judge's judgment. She's pulling the threads together, not just in relation to those points, but of course, by now, she has already mentioned the Rent Restriction Act. It comes up again in the next two paragraphs. That is absolutely fair and correct to say. But you can tell that she is working her way to her conclusion when she says, with respect, that this is her final point, and it's the first sentence that really matters because it's a summary, in my assessment of the claimant's credibility, which is what she describes as the inherent implausibility or improbability of the case as presented. And how I want to describe that, and you will see what she says there. Can I just leave you to read it to yourselves just one more time? I won't read it to you, and then I'll make my submission. And can I ask you just to go over to the page, just paragraph 71 and 72 for completeness? You probably have already done so. I'm so sorry.
I think so.
My obliged, my lady. So, what the judge is doing there, and is not just pulling the threads together, she is coming to her final conclusion, having done so in three important respects. She has, with respect, approached the evidence with a degree of appropriate professional skepticism. That is to say, she simply hasn't relied upon only the impression that the witnesses have made upon her. She has tried to ask herself the following testing question as to whether or not the story that she has heard ought to be believed, quote unquote, on its internal merits. In other words, is there a degree of internal coherence or plausibility, as she puts it, that allows her to accept what they have said? And you will see that in those paragraphs, she finds herself unable to do so, and she gives her reasons. What this court would have to test is whether or not the Court of Appeal was entitled to go behind those conclusions as set out in paragraph 70, 71, and 72, irrespective of any alleged error or misdirection. In other words, what the Court of Appeal, the task it had set itself was really coming to a different conclusion on the facts from the ones that she had arrived at. And of course, the authorities are very clear that just because the Court of Appeal has a different analysis, that's not sufficient. What was required was a determination by them that her conclusion was one that no reasonable tribunal directing itself properly, and we're leaving aside the rent restriction issue for the moment, could have come to. That is not what they say in their analysis. There is no...
I mean, the points at 72 and 73 are, one, the implausibility of an agreement based on values in the 1960s.
Yes.
And secondly, the fact that none of the claimants had mentioned this agreement until very late in the day.
Absolutely.
I mean, the Court of Appeal don't disagree with either of those assessments, do they?
Yes.
They accept the implausibility of the price point.
Yes.
And they don't, as far as I know, dispute the fact that they didn't raise the point until much later. I'm not quite sure how they deal with that, but I mean, so it's only really the rent restriction point on which there seems to be a difference between the judge and the Court of Appeal.
I'm just making sure that the way that issue is dealt with is to be found at page 876 of the same volume. And just by way of observation, my Lord, I'm on paragraph 47E. The heading is the inherent improbability of the story presented by the claimants. And my Lord is right. They do say that it was open to the judge to reject the agreement in the exact terms. But I say with respect, they didn't go far enough. They say it didn't automatically follow from that their claim to each to be a beneficiary of a proprietary estoppel in their favor with respect to the land occupied must fail. And we say with respect that what they did not do is have regard to the other points that my Lord just mentioned about the ex post facto, as it were, raising the fabrication point. And far more importantly, they don't deal with what the judge says about fabrication at all. It's not mentioned by the Court of Appeal. And I say with respect that that's a serious error on their part. Insofar as the Court of Appeal felt entitled to criticize the learned judge in some respects, but accept her findings in others, that they did not, with respect to them, apply to their own reasoning the degree of skepticism that she did, which is to say, having identified, as she did, that she was concerned about fabrication, I think at least two paragraphs. Paragraph 74 is one of them, where she says, and I quote, that's page 601, I find the claimant's position to be inherently implausible. So I'm on the implausibility point, and improbable. Indeed, looking at the facts in the round, they certainly suggest that the agreement may have been a fabrication of the claimants to deal with the situation that arose because of their failure to obtain a second 30-year lease and the absence of any provision in the Act for compensation in cases such as these. So she is putting very clearly what her process of reasoning is, and the Court of Appeal, to the extent that they don't disagree with her, either one of two things. Either they're taken to have accepted it, but far more cogently, I say with respect, that to the extent that they felt able to come to a different conclusion, it was incumbent upon them, a la Lord Reed and McCready, to deal with each of these points in her reasoning. And that is what they failed to do. So that if I say with respect that what has happened in this case is that the Court of Appeal, with great respect, in this particular instance, has taken issue with the learned judge's conclusions and not done so in accordance with the criteria set out in the legion of cases, only some of which are in the bundle, which require them not just to say I disagree on an aspect of law, but to confront the learned judge's reasoning, and therefore to enable anyone who's reading their reasons to know exactly why they came to a conclusion that was contrary to its interest.
But if they were satisfied that she'd misdirected herself,
Yes.
not expressing any view, on a material point,
Yes.
that would be sufficient to set aside the judgment, and they would then have to start to consider whether they could make findings of their own,
Absolutely, milady.
without having to go into every other item that she considered.
Milady, all I'm saying, because I'm not putting it as high as milady puts it, go into every other item, but insofar as a trier of fact says not once, but twice, I am concerned about fabrication. With great respect, it's not good enough for the Court of Appeal to go island hopping. They can't say, well, I'm going to deal with this reason because it's easier to knock over, and I'm not saying that's what happened, and I'm not prepared to deal with this other reason. Each of the fundamental building blocks of her reasoning process demanded there, with respect, attention, and if they felt able to, refutation. To the extent that there has not been a notice of it or a response to it, I say that there is a serious question as to whether they crossed the first threshold for intervention, but even if they did, even if they felt themselves able, that their reasoning is defective for the reason that I just gave.
But surely, if they were considering an alternative claim, they simply had to consider those matters that were material to the alternative claim.
Milady, all of the evidence is material to the first claim or the alternative claim, or what in reality was possibly not really an alternative claim, but a diluted form of relief. Because, and I did say that I would take you to those to this particular subparagraphs of the Court of Appeal's analysis of the pleadings, where really it's alternative relief, milady, with respect, as opposed to an alternative claim. So I say that when one reads the pleading, that what one sees very clearly is a commitment to establish the Andrews Agreement, but what the relief that they ask for is relief not framed around the Andrews Agreement, but is framed in more general terms. So I say with respect that the relief as claimed or as framed by the respondents is not, strictly speaking, an alternative at all. There were a series of declarations seeking equitable relief that were, it seems to me, milady, and milady may take a different view,
No, I'd just like to just see what your reaction is. If it's
Yes.
estoppel by acquiescence,
Yes.
then it's acquiescence in mistaken belief on the part of the respondents that they had rights, so that sort of presupposes they'd failed to establish any rights. The only question would be...
No, I accept that.
Yeah.
I accept that. I suppose my point is not a legal, I'm not entering into a legal dispute with milady. I accept the accuracy of what you just said. I am planting my flag on the pleaded case. There is no real distinction between my learned friends and I as far as the law is concerned, whether it's the law as to estoppel or the law as to how that estoppel is to be satisfied or anything of that sort. Can I, for completeness, take you to those paragraphs? Yes. Can I ask you to look at paragraph 52 of the Court of Appeal's judgment? And that's one volume I want you to have open. And in light of that, so my lady and my lords will see there that they take issue, and this is how I open my appeal, they take issue with what the little judge said, that they say that the case would not fall or stand on that basis. And so, lady, can I make perfectly clear that my position is very simply this, that the rejection of the evidence means that the primary case falls, the alternative case falls, the secondary case falls, all of the cases, with the exception of Lantern and security of tenure case, go, because the evidence is not believed. So my lady and my lord see what is said there. They say there was acquiescence in the permanence of, and they say that the argument was telegraphed at page 64 of the transcript of the oral submissions. I'm not going to, I'll take that in a moment, but I want to invite your attention to the two, so if you can divide, so paragraphs 10.3 and 10.9 concern the first respondent, 11.21 concerns the second, 12.5 concerns the third. And it's worthwhile, I think, for us to look at those pleaded paragraphs, and you will find the pleading in volume 1. You will find those paragraphs, the first ones, 10.3 and 10.9, on pages 16 and 18 respectively. So that what the Court of Appeal is dealing with, just for completeness, is the suggestion that there were equitable rights based on proprietary estoppel, and with an alternative case sufficiently pleaded or raised on the pleadings, more so in the evidence that there was acquiescence. So if we look at 10.3 and 10.9, it says that on the 15th of July 69, that's Mary Gomez's husband was informed by Messieurs Wong and Sanguinet that the lands were sold to Mr. Hanif, who is the father of the appellant. He's also, we can leave out the next sentence. He was aware of the promises and assurances made by the Andrews. So that goes back to the primary case at paragraphs 8C and 8D. He arranged for the rent to be paid to him or his daughter, Shafina. Hanif and Shafina informed the first claimant that any time she had the money to purchase the lands, it would be sold pursuant to the agreement of the market value. Again, that goes back to the primary case of 8C and D at the date, as valued as undeveloped lands at the date of their agreement with their predecessors. And the alternative is that they were encouraged or led to believe that if you continue to rent the lands and maintain the home, they would in future own the lands. And so we say with respect, single sentence, it flows from the very same case, and that thereafter, pursuant thereto, they paid the rent. So respectfully, we say no alternative case, properly raised 10.3. Let's go to 10.9. Bearing in mind that these are particulars of 10, which flows from 9, which flows from 8C and D. 10.9, the defendant encouraged her. And
these all say the same thing. They all...
Absolutely.
No, you don't.
Yeah, they say the same thing over and over again, which is, I mean, that's not, I'm not criticizing, I'm just saying, my respectful submission is no alternative.
Your point is that those paragraphs don't reveal anything alternative to their primary case.
I can stop. Yes, you got it.
But did Mr. Maharaj on page 64,
Right.
what's meant by him telegraphing?
So if I can, page 64 is to be found, I think, in the submissions, which is volume 6. So if I invite your attention to, it's my learned friend's oral submissions, my recollection, at the end of the oral trial. I think, doing the best I can, I think it's page 2500. I don't know if my lady and my lords have it.
Volume 6.
Volume 6. Can I just ask you for completeness to pick it up at page 2499, just so that you have a complete context? And then you can go over the page to see how he puts what he says is the alternative. And the words alternative submission appear at lines 14 to 15 of page 2500. And if my lords and lady could read that to the end before I say anything further. my learned friend Mr. Strange has invited me to bring to your attention as well 539, that's volume 2 of my learned friend's written submissions, and I'm happy for that to have been done. 539, my lord. And he says particularly paragraph 39A, and I'm very grateful to him.
Paragraph 39.
39A, my lady, yes.
Yeah.
It's a very short paragraph, and perhaps, I don't know if my friend would accept, puts his oral point very succinctly. So my simple submission on these paragraphs, on these sections, is as follows. They do represent an alternative submission. They don't represent an alternative case. An alternative case has to be pleaded. This board has decided in the case of Bernard and Sibalak that I'm entitled to know what case I have to meet. And I say with respect that this submission I telegraphed when I said this was my friend's fallback position. And it's been one of several. And I don't make any criticism of him in that regard.
Do we have the extract from Spry on which he relies? Or?
It is not in the bundle, but my lord, if you wish it, we'll try to get it over the short adjournment.
It's probably sufficiently there in the quotation.
I might see the authorities.
And it may be, my lord, this may or may not matter, that there is a more recent edition as well of
I'm sure there is. I'd just be quite interested to see the authorities which are referred
Yes.
to.
Well, my lord, if we can get them, we'll let you have them both. Both this extract as well as whatever the current statement is.
Isn't this rather water under the bridge, Mr. Benjamin? You began your submissions this morning showing us the learned judge's paragraph 29 and paragraph 30, and what she's addressing is a claim based on estoppel.
Yes.
So it's all water under the bridge.
It is, my lord. It is.
In a criminal case, does a judge have to make this sort of direction to the jury, members of the jury? Just because you feel that you conclude that the defendant has given false evidence in one respect, you mustn't write off the whole of his case.
Yes.
You must consider whether the other aspects of it nevertheless sustain a valid defense.
Yes.
And if criminal judges do that sort of thing, should Jones J. have said that to herself?
My lord, my answer to that is yes, and I go further. She did. So that when I drew your attention to what I have described, perhaps loosely, as these are the steps that she was taking to check the reliability and cogency of her findings, she was adopting a skeptical approach which says, it doesn't mean, and let me just use an example, the fact that David Sammy lied about the extent of his adverse possession, and I put that, or didn't tell the truth about the extent of adverse possession, doesn't necessarily mean that he's not telling the truth about the evidence that he's given. But what we can't do in the course of this appeal is take you to each and every aspect of the cross-examination where the judge had a factual basis for rejecting all of the evidence. In other words, I don't know how my friend proposes to do it, but in this case, there were a variety of instances which went to the core of the respondent's case that were not peripheral. And by way of direct answer to what my Lord has asked me, I say yes, the judge needed to look at all of the evidence and ask herself the question, not just because I disbelieve one aspect of it or one aspect of the evidence, do I come to the conclusion without caution and restraint that the case is not to be accepted? And I say with respect that that's exactly what she's done. In each of the paragraphs that I've drawn to my Lord's and my Lady's attention, that I have described in the way that I did.
Surely the point applies, I'm so sorry. Mr.
Yes, of course, my Lord. Lady, sorry.
It applies to alternative claims.
Yes.
That having rejected one on the grounds of credibility,
Yes.
she would have to direct herself, and it's quite common, as my Lord says, for judges to give themselves this form of direction, that they wouldn't necessarily be lying about the alternative claim.
Yes. My Lady, I accept that, my Lord. I accept that, my Lady. Save and accept that the way that the evidence was led, the question that she had to ask herself was not whether there was a different body of evidence that applied to the alternative way of putting the claim, because there wasn't. The question that she had to ask herself was whether, when I look at this evidence, can I find cogency in the alternative way of putting the claim? And I say respectfully, she did that. That's my respectful.
I mean, as far as their case was concerned, there wasn't an alternative case. Their case was they were given these assurances in a particular form back in the 60s, one of which was they'd be able to acquire this land at its then undeveloped value. And the alternative case assumes that they were just given a general assurance they'd be entitled to have some interest at some time fixed by reference to a completely unknown formula. And so, and you would say, well, she looked at that. And
my Lord and my Lady, my respectful submission is that she looked at everything.
Well, could I just ask you then about one factor she might not have looked at, namely the incontrovertible fact that they had invested a great deal of money in constructing houses on the land. And then if that were so, then the question would be whether there were inferences to be drawn which would confirm or reinforce any alternative claim.
My Lady, first of all, that was a subject of cross-examination, of extensive cross-examination. And the effect of that cross-examination was as follows, that the cross-examiner, Mrs. Peake, put it to each of the witnesses as they went into the box that the figures that they were advancing as having spent, so let's just take Ms. Gomez. Ms. Gomez, whose husband's salary was in the low hundreds of dollars, was advancing the suggestion that over a period of several years, she and her husband had spent more than $120,000 by way of investment into the property. And the suggestion that was put was, the figures that you are advancing are simply unreliable. So the first observation that I make respectfully is that that specifically was put and was tested and was, with respect, found wanting. And it contributed to the judge coming to the conclusion that she could not accept the evidence. In anticipation to the perfectly fair observation, well, that's not said in her judgment, Mr. Benjamin, I would have to put up my hand and say, yes, that's not so. And rely upon Lord Hoffman's observation, and Piglowski, I've given you the reference, where this is exactly the sort of thing that happens before the trial of fact. That is to say, you listen to all of the evidence, and you come to a conclusion about the impression that that evidence makes upon the judicial mind without necessarily identifying it. Because what difference would it have made? Why did they feel the need to embellish their case? And in fact, she criticizes expressly the third respondent for exaggeration. And she says that in her judgment. But they chose to give figures which were not consistent with other aspects of their evidence, and therefore, my lord, that's an example of telling perhaps an unnecessary lie, maybe not. But as long as the judge, any judge, not just this judge, approaches the material with a degree of reserve and directs herself in the way that she did, my lord and my lady and my lords will remember she put it in this way. She says, well, this is a case in respect of which there isn't a witness who was alive at the time on the other side. She uses the language of a blessing and a curse. I draw that to your attention to say that's exactly what my lady is suggesting she ought to have done, which is to consider it carefully and skeptically, without painting with too broad a brush, is exactly what's happened, or what did happen in this case. And that the salvage attempt advanced by the Court of Appeal simply does not go, with respect, far enough. My lady, can I not say anything about the plethora of Court of Appeal appellate decisions that talk about appellate caution?
I think we know what the position
know it,
is.
and I simply put it in so that if you felt that you wanted to get a reference, then it's there.
It's there.
It's in my written case. There is no difference between my little friend and I. I see that they've given you additional material, White House and Jordan, and so on, and there is an additional case in here which talks about lies in one respect and so on. Can I say, in anticipation of what I might not have to say in my reply, that I accept the accuracy of all of that law, and can I say as well that none of that is going to be determinative of how you decide the appeal. That allows me to invite your attention to the question of how the Court of Appeal decided that this particular equity that they found to be in existence should be properly recognized. And can I invite your attention to those paragraphs of the judgment where the Court of Appeal does that.
Can I just before you leave the background,
Yes.
do we have any evidence of what the value would have been of these plots? I mean, this is undeveloped forested land
Yes.
in the 1960s or
Yes.
late 50s. I mean, I can't believe it was very substantial.
We have no direct evidence.
No.
There is no valuation evidence. There was valuation evidence only of the houses.
Yeah.
In fact, if you go to look at any of those valuations...
That doesn't help us at all.
Correct. That doesn't help at all. But the cross-examination did touch on it indirectly in this sense. In 1969, it is a fact that Hanif purchased the property for $6,000. And that what he purchased for $6,000, 600 pounds in your currency, was 10 acres. And that was several multiples in terms of area of what each of the respondents were occupying. We know from the facts that...
Yes, I mean, I don't need to go into too
No.
long, because I'm just trying to understand, because they were expecting to get the land at that value, which you say was pretty minimal. And that was...
Again, I gave you that long run-up because I don't want to be giving evidence, but just to say that this material is to be found in the record, and the figure, on the assumption that arithmetic is an appropriate way to approach it, would end up being in the vicinity of perhaps $100, $120 for the lot. In other words, if you pay $6,000 for 10 acres, and you want to know what 5,000 square feet would cost, in fact, at page 2320, Mrs. Peake put a specific figure. That's volume 6, my lord and my lady. 2320.
2320.
2320. Lines 9 to 14. And perhaps it's worth reading it out to you. And this is her cross-examination of Mary Gomez, the first respondent. asking my lord the very question that you just asked, well, what was the price? And she says, but you didn't know the price, madam? You know what I mean. If you tell me it's $10,000 and you tell me your husband is only earning $100 a month, I could understand. But you have no idea of the price? Because if it was $68, which is what I'm suggesting, it would have been based on what Mr. Hanif Mohammed paid. Maybe you could have afforded that. You didn't think you could have afforded that in 1966? And then you see her answer. We wasn't thinking about buying land. And so the answer is helpful, at least to my case, not to my learned friends, in two respects. It helps my lord get a feel. We're talking about less than $100, $70, $68 in Trinidad and Tobago currency. In 1968, that's £6, if you converted it now. But also the answer that she gave, that they weren't thinking about buying land, but, the whole case is premised on the basis that they had an option to purchase, and therefore somebody at some stage must have thought the opposite of what she said. So I don't know if my lord finds that helpful.
Well, it's interesting, yes.
Yes, well, that's the correct.
I mean, the rent they were paying was $12, was it?
The rent in the early period it was $12, and then it went up incrementally. So by the time it got to 2010, they might have been paying $58, $59, $60 on an annual basis.
But they were claiming that they could have bought the freehold for $68.
All that could have been put in the absence of expert evidence as to what the values would have been is that I think that there'll be no contest between my friend and I, if I put it this way, that the value in the 60s would have been very modest. If you use simply as an analogy, as inexact as it is, that in 69, 2 years after the last person went into occupation, a 10-acre parcel was purchased. That 10-acre parcel upon which these three parcels are to be found was purchased for $6,000.
You have the reference to that?
For the deed?
For the $6,000?
Yes. You will find it in the chronology. I will give you the precise reference if you just give me 2 seconds.
I'll come back to it.
Yeah, it is in the chronology, but I can't give it to you now.
I've got the chronology.
Yes. 14th of July, 2069, Volume 4, 1721.
Thank you.
What did I just say? 1969, Volume 4, page 1721. Is one place where you will see the deed. It appears in many other places as well.
And do we know, just to finish this line, what the market value would be under the Court of Appeals order? I mean, they say just half the market value.
That's much more difficult, and no.
We don't.
Because the way, and it's a helpful segue into the order, and a helpful segue as to whether they should have made an order with respect, in respect of which there is no evidence at all. In other words, there's no evidence, because the form of the Court of Appeals order was that the respondents were each to be granted a 15-year lease with an option to purchase at 50% of the market value, as determined at 2011.
But the market value is simply of the land, not of the...
Absolutely, my lord, yes. And again, in answer to what my Lady Hayden Arden has been putting to me, we're only concerned with the land. And there was no evidence, there was no attempt, there was none at first instance, and there certainly was no additional evidence at the level of the Court of Appeal, which could have informed, I'll put it that way, could have informed the Court of Appeals order as to what the value of the land might have been, bearing in mind that they're giving a decision in 2016, 2017, and they have determined a date as of 2011, and therefore it would have been in theory ascertainable had there been any advance notice that would be what might have been in their contemplation. The way that this issue was left with the Court of Appeal was that the submissions on both sides didn't go beyond an application of the relevant principles as set out in the by way of example of this board's decision in the Henry case, which is in the bundle, which is to say that what the correct approach is you look at the respective advantages and disadvantages that the person who is making the claim has incurred. You also look at the position of the other side, the person on the other side of the transaction, and come to a conclusion. Our respectful criticism of the order was that this is an example of the sort of material that the Court of Appeal did not have, and therefore it's not at all clear what was the basis upon which they came to the conclusion that this was the appropriate measure of relief. As you know, their analysis begins at page 888 of volume 2 of the record. It's paragraph 79. I have already indicated that there is no difference between my friends and myself as to what the law is. The Court of Appeal decision is quoted. It refers to a decision of this board in Henry. For completeness, that decision is to be found at tab 17 of the Joint Bundle of Authorities, page 3390. The decision was given by Sir Jonathan Parker. Other members of the board were Lords Hope, Brown, Mance, and Clark. And at paragraphs 80 to 84, the weighing up process is described in, I respectfully would suggest, generic terms. In other words, the weighing process involves weighing any disadvantages suffered by the appellants, then the respondents, by reliance upon the appellant's alleged inducements or encouragements.
I'm sorry, where are you?
I'm so sorry. I've gone over the page to 890. I began at page 888. I was skipping over the references to
We're on the authority, which begins at page 3392, tab 17.
Yes, I was simply giving that for your note. I didn't propose to take you to it.
Oh.
Oh, I apologize.
So where are you? Where were you taking
so let
us
me
to?
start again. I am at page 888, the decision of the Court of Appeal.
Oh.
Okay.
There, the Court of Appeal identifies issue 5.
Mm-hmm. Yes.
And I was simply observing that our Court of Appeal has adopted the board's decision, the board's analysis, the board's approach in Henry. That's why I gave you the reference. But I was giving myself a let out by saying there is no difference between my friend and myself on the law, and therefore, unless you insist, I didn't propose to try to debate it with you.
Well, as far as I understand you, there is no difference between you as to the law on any point.
You're correct, lady.
Just how it applies in this particular case.
Well, there is a difference. There may be a difference as to the application of the law.
Well, that's what I just said.
Yes, lady. I'm getting to the end of my time, so I'm bound to hear what you say correctly and think that I didn't say it accurately. I do apologize for that. So paragraphs of that judgment, 79 to 80, there's no issue between us. In paragraphs 82 to 83, they set out a generic summary of that weighing up process derived from those very same paragraphs, set for themselves the task of quantifying the interests at paragraph 84, say that they're not going to interfere with the question of price at paragraph 85, which is really not an issue, identify accurately that they have been there for more than 50 years and are elderly, and say that they should have an option. At paragraph 88, they acknowledge the appellant's argument, or rather the respondent's rejection of our argument. They are saying they were not statutory tenants. And you, my lady and my lords, will remember in my written case, I did suggest, my friend doesn't accept this on the other side, as I didn't expect him to, that the Court of Appeal, the way that I put it was they had extended the reach of the statutory provisions impermissibly. I was trying to find a way of communicating that they were directly influenced by the criteria set out in the Act. So what you've got is a situation in respect of which a Court of Appeal says, we don't agree with what the judge at first instance has done. We think that we have to find a way forward, and they purport to apply the Henry and Henry principles. But the one thing that this board's decision in Henry is not authority for is for the idea that as part of the equitable weighing up process, you can analogize or extrapolate from the provisions of the Land Tenant Security of Tenure Act. And so here you get an acknowledgement at paragraph 88 that that clearly is a factor that they have in mind. They are looking at the provisions and they are going to draw an analogy with it, and they have done so. Paragraph 89, they simply reflect the fact that they built and rented land, they built an occupation, etc., etc. And then paragraph 91, with great respect, and I mean no disrespect by the next two words I'm going to use, hey presto, we get their order. Now, there is, with respect, no logical, evidential, forensic, or coherent basis in the evidence that they arrive at the conclusion that they get at paragraph 91. In part for the reason that I've already given you when I answered my Lord Carnwath's question about is there any evidence of value as at that time.
But if it is the formula they adopt consistent with the formula under the land security?
It's a different formula to this extent that what you have the right under the Act is when you make your request, that triggers the date,
yes.
But it is 50% of that value.
Yes, but the value of the land without the house.
No. It's the value of, it's the market value of the land. When you go to the provisions, and I want to be certain.
I think that's right. I mean, this is what's called a chattel house, isn't it?
Yes, as defined.
The way I understand the Act, tell me if I'm wrong, it's the value of the land without the house.
Yes, I
and half
apologize.
of
I
that
said the
is
opposite.
taken.
Yes.
They're proceeding on the basis, well, they assume that they'd exercise their option in May 2011.
Yes.
And that's the way they do it.
Yes. So the difference between the statutory formula and the form of order as articulated by the Court of Appeal is they have chosen a date.
Yeah.
So I was going to ask you a question about this, and I know time is running out. I must ask it very quickly.
Yes.
You don't like the analogy with the 1981 Act. Okay, we understand
Yes.
that point. If there is an analogy, if they were right to borrow from it,
Yes.
why did they favour a valuation date of 2011 rather than, as per the Act, a valuation date as the date of notice of exercise of option?
The only answer I can give is because they had not renewed their tenancies by then, any date after that would not have been notionally open to them. In other words, no renewal of tenancy, therefore the tenancy has come to an end, and therefore they have chosen a date at literally the moment before the termination of the tenancy. That is my educated guess. I honestly do not know the answer.
It's not explained.
But that's the date, isn't it, on which your client said that they had ceased to be entitled to occupy the land?
Yes, which is...
So-
But it's not the date of any purported exercise of any option.
It's 30 years since the commencement
It's
of the
30
Act.
years, but they haven't exercised the option, is the point.
But it's on the assumption, which was the one your client made,
Yes.
that the Act applied
Yes.
and gave them a 30-year
Yes.
tenancy from the commencement of the Act.
Yes, my lady.
And that's why he said, and you haven't renewed it, and that's
Yes.
why I want
Yes.
possession. Thank you very much. So,
That's what I was trying to convey, but as usual, my lady got it with greater clarity than I did, and in time as well. My lady, may I be allowed to take my seat? Can I thank you for the kind attention?
Oh.
The questions.
thank you very much indeed, Mr. Benjamin. Mr. Kalwar Singh? Thank you. Mr. Maharaj.
Much obliged, my ladies and my lords. As I see it, at the heart of this case, of the appellant's appeal, is whether the appellant has been able to show that the Court of Appeal was not entitled to revisit the findings of the learned judge in respect of the claim for proprietary estoppel. My learned friend has approached this issue on the basis that the Court of Appeal was assessing or revisited the findings of the judge on the basis of drawing inferences from the credibility found by the judge in respect of witnesses. This is not what happened in this case. What the Court of Appeal did, the Court of Appeal revisited the findings of the judge because the Court of Appeal found that on the undisputed evidence in respect of the permanence of the buildings, the monies expended, and all that went with it, the labor and etc., on that undisputed evidence, it was reasonable for the court to draw the inference. And there's a distinction between drawing an inference from undisputed evidence and a Court of Appeal drawing an inference from the findings of the judge in respect of credibility. And I will come to that later because the cases make that very clear. There is a distinction. And we would submit that the appellant has not discharged the onus which he has to show to the board that the Court of Appeal was plainly wrong in revisiting the findings of the learned judge and also in making the findings the Court of Appeal made in respect of the undisputed evidence. What I propose to do, I would like to begin by summarizing my arguments in response in 3 stages. And if I could give you those 3 stages first. First, the Court of Appeal was entitled to revisit the question of what findings should be drawn from the permanence of the respondents' homes. They took a correct and cautious appellate approach in doing so. The second stage would be that the Court of Appeal was entitled to find that the Andrews had promised the respondents an option to purchase, and the appellant has shown no reason to disturb that finding, in my respectful submission. And thirdly, the Court of Appeal was entitled to award the relief that it did, and the appellant has shown no reason for saying that it went wrong in the exercise of its discretion. In respect of the first issue, that is whether the Court of Appeal was entitled to draw its own inferences from the undisputed facts, I summarize the respondents' arguments as follows. As the judge had found that she could not rely on the respondents' credibility, she found the important issue was what conclusions could be drawn from the undisputed facts. On this question, the Court of Appeal approached with the proper appellate caution. It accepted the judge's findings on credibility and considered the undisputed facts. With regard to the undisputed facts, the respondent's case was that they would not have built these permanent houses at significant cost and personal effort on their part if they had not believed that they had some security of tenure. The respondents argued that this belief was consistent with the agreements they alleged. The judge rejected that argument, saying it was equally consistent with the security of tenure provided by the 2 acts, 1981, the Land Tenants Act, and what she called the predecessor, the 1942 Rent Restriction Act. The Court of Appeal was right to say that this is where the judge went wrong. She went wrong in the following ways. 1, the 1981 Act was irrelevant. It could not explain events before 1981. These were houses built in the 1950s and 1960s, when the 1981 Act was not available. 2, she was wrong to rely on the Rent Restriction Act because it had not been raised before her. She raised it for the first time in her judgment. 3, in any event, the Court of Appeal found the Rent Restriction Act did not apply to the respondent's lands, and I will submit that the Court of Appeal reasoning was sound when I come to that, my lady. And in any event, even if the Rent Restriction Act did apply, the fourth way the judge went wrong was that there was no evidence that the respondents even knew of the Act. So it could not properly have been relied on to explain their conduct. And fifth, it did not provide anything like the security of tenure of the 1981 Act, although it was the protection of the 1981 Act on which the judge appeared to rely in her reasoning. It follows, my ladies and my lords, I will submit that the Court of Appeal was right to revisit the question. What findings were to be drawn from the undisputed facts of the respondents' permanent homes? Once that is accepted, then it is for the appellant to show that the Court of Appeal finding was wrong or was not open to the Court of Appeal on the evidence before it. And in relation to the relief, it is for the appellant to show that the Court of Appeal erred in its discretion on what was or was not entitled to make the award that it did. I now turn to the undisputed facts of the respondents' permanent homes. In the light of the judge's findings on credibility, as the judge rightly said, it was important to assess whether support for the respondent's case could have been found in the objective or undisputed evidence. Of particular importance was the undisputed evidence that the respondents, at significant expense and effort, took plots of undeveloped land and made permanent homes. And you would see from the evidence, this was not just taking the undeveloped land. You had cases where they had to manually burrow into the mountains to level the land, which took labor and took time and took effort. This is not a case where they had a bulldozer or an excavator. They did this with the knowledge and consent of the Andrews and their successor entitled, Mr. Hanif Mohammed. These were the undisputed facts, and if I may enumerate some of them. The land when the respondents took possession of was uncleared bush. Next, their plots were located on mountainous forested terrain. They cleared the bush, leveled the land, they built homes, and over time extended and improved them. They cut a track and later widened it and extended it. They put in water and they put in electricity. These facts were well summarized in the evidence of Mr. Theophilus Nirgun, who was not related to any one of them. He was a neighbor, whose evidence on this was not challenged or disputed. And I could take you to volume 3 at page 14. Have you found it? Have you found it, my ladies and my lords?
I have it,
Okay.
1458.
At
yes.
paragraph 4, if I can start there. At paragraph 4, if you look almost to the end of that paragraph, starting with the word before, before the second claimant and her family moved onto their lands, the main parcel of land was mountainous and forested and bushes, trees, and scrubs. And then if you go to paragraph 5, starting with in 1958, I observed Henry and the second claimant, Shira Mohammed, clearing a spot on their lands and constructing a 2-room concrete structure in which they live with their children. In paragraph 6, beginning in the 1960s, I observed Henry on most afternoons when he came home from work, would dig into parts of the mountainous lands around his dwelling home in order to level the land. At paragraph 7, I also recall that sometime in the early 1960s, Henry and Shira Mohammed, what was that? Turned a truck which they had leading to the main road from their lands into where a dirt
It's wider dirt access.
dirt access road, a wider dirt access road. At paragraph 9, I also saw when in the early 1960s, when the third claimant, David Sammy, and his wife moved onto the main parcel of land, the location of the lands which they occupied was very steep, and they also had to dig into the land. Finally, at paragraph 10, talking about Mary Gomez, starting from, the second sentence, I also observed that when they cleared the parcel of land which the first claimant continues to occupy, they also initially constructed a 2-room dwelling structure. A few years later, I recall they obtained electricity and water connections, and over the years, etc., etc. The assessment of these facts was highly material to the determination of the respondent's case, because the fact that they built permanent homes at great effort and expense would suggest a belief on their part that they had some security of tenure beyond that afforded by an annual tenancy. If they had such a belief, that in turn raises the question whether, as they claim, the belief arose from a promise that they could buy their land when they were ready to do so. I now turn to the relevant law.
Well, that seems like an appropriate moment at which to adjourn, and look forward to hearing from you further at 2:00.